Hi everyone, welcome to our unit on intellectual property law. There are really three big topics we're going to cover in this one unit on intellectual property law, and that is patent law, copyright law, and trademark law. Together, they're all types of intellectual property law. Notice the two words that are in intellectual property. It's a really great name, I think, for an area of law, because we've already talked about property rights in this class. In fact, we talked about them in our unit on contract law. When we were learning about the statute of frauds, we talked about certain contracts that have to be in writing to be enforceable. And if you remember, one of those types of contracts that has to be in writing to be enforceable is a contract for the sale of real estate. Well, real estate, another word for that is real property. I put a picture of a house here. When we talk in the law about real property, we're talking about land or the structures that are permanently attached to land. So that would include the land where your house or building is located on, the trees that are on that property that are, affixed to the ground. It would also include structures that are permanently put on the property. So a house, a building, a shed, a garage. These are all parts of real property. And there's a whole area of law governing the use and buying and selling of real property rights. We also have a lot of law devoted to the study of personal property. Personal property are those items that you can pick up and move and take from one place to another, like all the furniture in your house is personal property. Your car and your telephone, those are in your computer. Those are examples of personal properties. And there's, of course, a lot of law that relates to the governing of buying, selling, and using your personal property. But the area of intellectual property is unique because it's an area of law that governs what's in our heads, our ideas. For example, if I develop song lyrics on my own and I want to hear my song on the radio, on Spotify, on Apple Music, on Amazon, and I want to make money off the sale of the song, I don't want someone else to just come up and use the song without my permission, right? That was my idea. That was my creation. So how is it that we have a body of law to develop to govern what's in my head? Because I don't want someone else to take or steal and use my ideas without my permission. That body of law is known as intellectual property. So that's what we're talking about here, is the body of law that governs what a person has created in his or her own mind and the protections that come with that. So there's three categories of intellectual property law. I'm obviously not going to cover all of them in depth in just this 1 week, but I want you to know the differences between the three, how they are, where those laws come from, just like we've talked all semester. Are they federal laws? Are they state laws? Where do those laws come from? How we get that protection, the differences in the three, how we obtain that protection and how long they last. So if I come up with an idea, an invention, how long is that idea my own before others can use it, buy it, sell it? So we'll talk about all of that in this PowerPoint, which will probably go on to 2 PowerPoints. The first one is patent law. Patent law comes from the Constitution. It's literally written right in the Constitution to grant the power to promote the progress of science for the use and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So take a minute and pause the video and read that again and see the power in this right that's granted to us in the Constitution, that our ideas, our writings, our discoveries, that the U.S. Constitution grants to the U.S. Congress, the federal Congress, the power, that authority, remember that word jurisdiction, to draft laws to give individuals like me and like you the protection of our ideas, but not forever. Notice how it says for limited times. So that's what we're going to talk about, is how long these last. Okay, so along with the U.S. Constitution granting to Congress the authority to make laws that govern intellectual property, the federal government has also created a federal agency, the U.S. Patent and Trademark Office. This brings us back to something else we learned about earlier in this semester, which is the creation of federal agencies, just like the FDA or the the different agencies that we talked about earlier this semester, the SEC. We're now back to learning about another one, the U.S. Patent and Trademark Office. So what this means is that all of this area of law, the patents, the copyrights, and the trademarks, are all governed by federal law. This is not an area where states have different laws from each other, like Massachusetts has one set of patent and trademark laws and New Hampshire has another. It's all the same no matter where you are in the United States. All right, so I'm going to talk about two different types of patents, although there is a third, there's a plant patent. You can read about that in your textbook, but I really want to talk about the design and the utility patent. A design patent is just like it sounds. It protects the design of an item. And so it lasts for up to 14 years. And I'll talk in a minute about how we apply for that patent, but this one lasts for up to 14 years. That's as long as the design patent lasts. An example of some design patents are shoes. I know a big thing right now are like designer sneakers that sell for like thousands of dollars. If you're the designer of, a fancy sneaker or a certain kind of shoe that, has never been designed before, then you can obtain a design patent. But notice it only lasts for 14 years. What happens at the end of the 14 years is that other individuals can copy and use your design after that 14-year period. You cannot reapply and extend the life of your patent. After that 14-year period, others can use it and copy it. But for that first 14 years that you're the ones that has the design patent, if someone else, and we'll talk about this on another slide as well, if someone else copies your design and uses it without your permission or a license to use it and paying you for it, you can sue them for patent infringement if you're the one that holds the patent. So 14 years for a design patent. The most common kind of patent is actually a utility patent. Look at how broad a category utility patents cover. Mechanical inventions, electrical inventions, machines, formulas, chemistry. What would fall under utility patents are medicines like Tylenol, and what's in Tylenol is acetaminophen. That's the generic name for Tylenol. Utility patents last for 20 years. So a pharmaceutical company, if they are the first to develop a patent for a certain medicine or a certain treatment, that pharmaceutical company has the opportunity to use that item or use that patent and that, let's say, formula or chemical invention for 20 years. And after 20 years, other companies can use that invention and then also make money with it. So again, a really good example would be the drug acetaminophen, which is what is in Tylenol. You can go to CVS or you can go to Walgreens and buy what we all know as the generic version of the medicine acetaminophen, but you can also buy Tylenol. And it's the same medicine. How is that possible? Well, Tylenol, and I think they're actually the parent company, I don't know if they have another name, they own the patent on Tylenol for that first 20 years. And after that, again, you cannot renew patents, so others can copy it. So utility patents and design patents, those are the two that I want you to know about. I put a little image of Amazon here, and you might be wondering how it is that Amazon comes up under utility patents. There's a really fun case involving Amazon back in the dark ages of the internet in like the 1990s. They were the first ones, I know this sounds hard to believe now, to develop the one-click technology. The idea that you could have your credit card number stored in the computer, and if you wanted to buy something, all you had to do was click once and you purchased it. Believe it or not, in the early ages of the web, it was a really big process to purchase items online. It required multiple steps, many windows to fill out, and Amazon came up with the idea of the one-click method. And there really was a patent lawsuit between Amazon and I think it was Barnes & Noble over the one-click technology and who was the first to develop it and patent it. Well, it was Amazon. Now, of course, it's actually been more than 20 years and we one-click everywhere we want on the internet. But that technology, that invention at the time was new and patented by Amazon. All right, a little bit about the patent application process. So again, we mentioned the U.S. Patent and Trademark Office. It is another massive building in Washington, D.C. that processes, as you can imagine by its name, application for both patents and trademarks. The thing about patents is it's an incredibly complicated and long process. And a lot of that has to do with the nature of the invention that is looking to be patented. We're talking about formulas, scientific equations, technologies. So when an individual or a company makes an application for a patent, the office needs to review it to make sure that it is original. I had on the other slide that it's new, that it's novel and useful, and that no one else has ever patented this technology before or this invention before. And so who works at this agency is a combination of lawyers, scientists, engineers, not just lawyers, but the individuals who actually understand the science and technology behind all these patents. It can't just be a lawyer who understands what the law is. You need the individuals who have that substantive knowledge. And so it can take, believe it or not, years to get your patent application approved. It's complicated, it's long. It can also cost several $1,000s just in the attorney's fees and process to get through the patent application process. But once you obtain that patent, that is a huge protection, as I mentioned, because it gives you, the holder, the exclusive right to use that technology or that chemistry, that equation, that design for either a period of 14 years or 20 years, depending on the type of patent. And I wrote the word patent infringement on here. That's the type of lawsuit that you, as the holder of the patent, would file against a defendant who you believe was using your patent without your permission and therefore stealing your ideas. So notice the power that this patent gives you is that power to hold it, the exclusive rights to this technology for that period of time, and no one else can take it. You might be wondering too about what happens internationally, because what would stop someone from another country stealing your ideas? These are just US laws. And as you can imagine, this is another complicated area of the law because there's inventors and developers all over the world. And in our global economy, we want people to live that way. But how do we protect our patents from being stolen or used internationally? So your book walks through a few different agreements that are international agreements among countries. There's not like a one-stop shopping where you press a button and just because you obtain a patent in one country, your item is automatically patented in other countries. But there are agreements among the nations to make the process smoother so that obtaining a patent in one nation is a little easier to then protect your rights in other nations that are members of this agreement. Okay, so that's a little about the area of the introduction to the area of intellectual property law and patent law. I'm just going to introduce the next topic here, and we'll finish copyright and trademark on the next PowerPoint. So I'll start with this. Okay, so this is our introduction to the area of copyright law. It might be hard to see in the picture, but this is a group of textbooks. And my question that I want you to consider as we move into studying the area of copyright law is, do you think textbooks for school are too expensive? I think you probably would say yes, and I would agree with you. So let's pose this idea. Let's imagine that a textbook for one of your classes is $100. And you're thinking, oh, that's so expensive. And in the meantime, let's imagine that one of your classmates is from the country of Thailand, and he goes home over a vacation, and he realizes the book in Thailand is only $40. So he buys, in Thailand, let's say 10, 15, 20 books, and he has them shipped back here. He packs his very heavy suitcase with 20 textbooks that he purchased in Thailand for $40. And then he says, hey, Sugarman, instead of paying the bookstore $100, I'll sell you this book for $50. Same exact book. Would you take the deal? So contemplate that as we move into talking about copyright law. Is that legal? Is that okay? Would you do it? I'm just here to tell you that I would. Let's pick this up with the next PowerPoint.